Raising the Bar podcast, brought to you by the Association of Gray's Inn Students.
Welcome to the podcast. I'm Lily Olliver. I'm going to be your host for today. On this episode, I will be talking with Saara Idelbi about the pitfalls of AI that students should be aware of when coming to the bar. Saara is a barrister and a co-founder of the AI platform Advocacy.
I am hearing more and more people in court now will have it running.
ChatGPT running.
Yeah, so they're trying to
case.
record what the judge is saying and then get the answers to respond. That's illegal because it's technically a recording. As video-generated AI gets better, we're hoping that we'll be able to develop fake witnesses so that you're cross-examining somebody. So the technology is there, it's just the videos that can be generated at the moment are very short. You can't have a long-term interaction like you would with a witness in a box. If it takes away the boring bits, oh yes, if someone could do my billing for me, yes, I don't ever want to have a look at my billing again. If it can just analyse from how long I'm in a document and then post that onto my worksheet, that would be ideal.
So Saara, thank you for being here, and it's really exciting to hear from you today.
I'm really pleased you invited me on.
Fantastic. So you have been doing lots on AI and the bar. And the first thing I wanted to ask, what is Gen AI? Can you give a brief introduction for this?
Yeah, so generative AI, shortened to Gen AI, is the sort of AI that we tend to experience most in our day-to-day life. Is what we think about when we think of ChatGPT, when we think about Claude, Gemini. It is a sort of artificial intelligence that is able to create and respond. It's been created by reference to or using machine learning, deep learning, which is a process of basically mimicking neural networks. Natural language processing, that just gets developed by inputting really large data sets into the model. And the model then uses that to train. And then what you interface with on a day-to-day basis with ChatGPT or Claude, it will be sitting behind the interface, but you're actually just talking to the model through like an application or something like that.
So when you ask it a question, it comes out with a response that it considers is most likely to be the answer you're looking for.
The most likely response to your question. So you could ask it the same question in substance, but if you used a slightly different set of words to ask the question, your answer will also be different.
And I've understood that AI is designed to be inherently people-pleasing. Would you say that's true?
Yes, I think that when you think about Gen AI and how you interface with it, everyone's experience of how they use Gen AI will be different. So the way you speak is going to be different to the way that I speak. So the words that I will select to talk to a model will probably be different from the words that you will choose to select when you speak to it, which means that the responses that you get will be completely different as it gets output. And so these tools are, you've got the model, you have the sort of interface, which is the application. And the application is obviously there to keep you engaged with it. So there is important degree of personalization. So it responds to you rather than to someone else. And the personalization comes to some extent from how you talk to it. It comes from where you're located. So if you are, for instance, in legal London and you ask a legal question, the IP will ping that it's looking for a lawyer's answer, not somebody who lives, I don't know, in the Outer Hebrides, nowhere near a law firm. And that will feed into how it answers you. And so you have that facet of personalization. It's important to say if you use ChatGPT or Claude or Gemini, in your settings, you can adjust how you want the model to respond to you. And so I ask my model to test its assumptions, push back because it's meant to be a strategic partner, debate concepts with me, and then when it gives me an answer, I will ask it, well, what's wrong with your answer, before I will accept it. So it then has to evaluate itself from both sides of the perspective, and that's something that you can actively do.
So when it tailors its language to you, would you say was becoming more accurate?
I think what it tells you is that you can't rely on it to be an objective partner. With all probabilities, there is a percentage chance that it will be right, but a percentage chance that it will be wrong. And if you are doing a task where the percentage chance of it being wrong is not good enough for the task that you are trying to do, that means you can't really use it for that task. So when you are asking it to look for or analyse judgments or legal positions, a probabilistic answer is not going to be good enough if you're working in a real case, because the real case has real people, real facts. They are anchored in something that's actually happened. So more likely than not, this answer is not going to be sufficient for, it doesn't matter what's happened here. What is it? How does the principle apply to this set of circumstances? And that's why you have to treat it with a lot of caution.
So the probabilistic outcomes it produces are uncertain enough to use in legal practice?
Yes.
Is that what you're saying?
For the most part. If somebody sort of sent you an email, would you mind doing this by X? Or, here's the document, and probabilistic response of, thank you so much, I really appreciate that, is obviously not going to be a problem for you. And that is technically a part of legal practice. But a response that says, these cases exist, this is their definite citations, that's a real problem, especially if you give it to the court, where you are effectively certifying that everything that you have done, you've done yourself, you've checked it, you know that it's accurate and true, and the court can rely on you for that. It's a huge part of what we do as barristers and solicitors as well. We're officers of the court, so the court has to be able to trust us without having to check our work, because the expectation is that we have checked our own work, even if it is produced by a pupil or a computer.
There was a case about this last year in A&D. What was the consequence in that case?
The consequences are still ongoing, but A&D, as people will probably be aware of now because it's been spoken about so frequently, concerned a judicial review of a local authority, and in so many respects it's a terrible set of circumstances. But the junior barrister in that had produced documents that included cases that did not exist. And I can't say that they're hallucinations because the barrister has not accepted, as far as I understand, that they used AI. And so we don't know for sure. That will be tested, as far as I understand, by the BSB. But the inclusion of cases that did not exist gave rise to proceedings under the Hamid jurisdiction, which is considering whether there's been a contempt of court. It happened at the same time as a case called Al Haroon, which is a national bank of some variety, where the solicitor had accepted a document that had been prepared by his client that had used AI, and so also included false citations in them. And it was in A&I and Al Haroon where the divisional court had said that it's now time, you've got to make sure that you understand the risks associated with AI, and for those who are training pupils and students, it's important that you make sure that people understand their obligations when using these tools. So that was a case where we don't know for certain whether or not the barrister in A&I definitely used AI. But what it does show is if they hadn't done, but let's say they had Googled something, you might know that last year Google made AI an inherent feature of its search engine, which has meant that I actually don't use it anymore. I use a different search engine, so I could not use it, because sometimes I just want to have an outcome that's a straight answer without something thinking it for me. But if they had used Google and gotten that AI summary at the beginning, it's the same model that powers the search engine. And so it could generate a false citation that if they had just copied, pasted, didn't check, it's just as bad as using the interface of the chatbot that says, can you answer this question for me?
Yeah, absolutely. So it's really important to be super careful. There's also another concern that's happening, which is that there's an increasing number of litigants in person. So that's people who are not represented legally, and they go to court by themselves and they argue for their case. Do you know what the issues for litigants in person with the use of AI are?
There are many. firstly, I think across the industry, we're seeing increasing numbers of documents prepared with the assistance of ChatGPT or Claude. And this is a good point to highlight that there is a huge capability difference between what you get for free and what you pay for. So the free models are suffocated in a way that the paid for models are not. And the quality of the output is much higher on any paid model with any paid AI provider.
How exactly is it much better?
So the outputs will be more detailed and they'll probably be better resourced because it costs to use a certain number of tokens. So if you're a free user, the objective of the owning company is to suffocate how many tokens you take up because you're not paying for it. Whereas if you're paying for it, it's more flexible because you're actually paying for that service. So if it's giving you just a quick answer on a reduced number of tokens, you're not going to know the difference between that and a paid answer. So that's one point that's really important to highlight. What you will get from a paid search will be very different from what you get from a free search. Then the second part is you can see people just using it to write long documents. And again, it's the most probabilistic outcome. So they sound sort of semi-coherent, they sound legal, but they actually lose the thrust of what the litigant wants to say. And that's a real shame because it means that the crux of their problem is missing amongst these long letters. But then you have the added problem, which is they are putting their documents, their information into these models. And you may have heard in the United States, a court there decided that chats with ChatGPT are not privileged. We've obviously got a different legal regime about how privilege works.
Just quickly, could you explain what privilege is?
Litigation or legal privilege is the right for you to have a discussion and get legal advice without a third party knowing what that advice would have been. So it's that discussion with your lawyer that you don't have to disclose to other people. There are obviously loads of exceptions, and here it's privilege is very complicated, but it meant that the client asked ChatGPT some questions that then took the answer to the lawyers, and that interaction can sometimes be considered legal advice privilege, because if I, let's say, if I was in a company and I spoke to somebody else employed by the company about a point that we wanted to get advice from counsel on, that interaction could potentially be privileged. There are, again, details around that make it quite complicated. But just because rather than speaking to a person who spoke to ChatGPT, I think actually it was Claude, my apologies, I think you spoke to Claude, the judge found that conversation wasn't privileged, which means the content of what he put in was available to the other side to see. And so if you're uploading confidential documents, you cannot assume that it's private. You cannot assume that you have not accidentally made available documents that might be used for training data. They really technically shouldn't be using it for training data, but we don't know what people do on the other side.
Who knows when they're doing
Exactly. And that causes problems for them. So in family cases here, I can't remember the citation off the top of my head, your prompts, so what you decide to put in, that's not privileged. That might be disclosable into the family court proceedings.
How can anyone find out what prompts you use?
It should be in your history. Now, theoretically, you can delete them, but obviously, if you've deleted them, you just leave open adverse inference for the courts to be able to take a view about how that's been dealt with.
So theoretically, they could ask to see your ChatGPT history?
Yeah.
Wow.
And your deleting of them, if you know that they might be relevant, is just like you destroying any other piece of evidence for the client. Then you also see, some litigants accidentally leave their prompts in the documents that they generate. Everyone's a victim of that. I think I saw it, I think a minister might have done it, or a counsellor, I'm not sure, but it was there. I am hearing more and more people in court now will have it running.
ChatGPT running.
Yeah, so they're trying to record what the judge is saying and then get the answers to respond, that's illegal because it's technically a recording, and recordings of court hearings is impermissible. Some people may not use the recording function, but if something is being said, they'll type it into ChatGPT, then get a response out, and then say that instead. And it's plausible sounding, but it's plausible sounding rubbish because it's ultimately not a lawyer. And that has an adverse impact on that person's access to justice. So it might be right some of the time, it might be wrong other parts of the time, and they've just lost their opportunity to do so. But there are a lot of legal startups at the moment that are trying to create a bridge between the open use of models like Claude and ChatGPT and create a product that might actually be more refined that can help them in dealing with these sorts of issues, claims and things like that.
So they can help litigants in person use access cases.
Exactly. So
it's super interesting.
Things work in slightly different ways. So again, like what we interface with is that chatbot AI interface where you can like type a question. But there are things like harnesses. So for instance, Advocator is a harness. The model that sits behind it is one of the frontier AI models. But then what companies build on top of it are ways to direct it in a certain way that increases the accuracy or the focus of the output. Legora, Harvey, all of those sorts of tech apps, they are just wrappers. Fundamentally, they don't use their own large language model behind it, but what they do is they put a wrap around it. So like a horse, you're focusing your energy on pulling a cart rather than just letting it run wild.
They know how to present the information.
And making sure it focuses on what information might be relevant for the task that it's got to complete.
So do you think that would ultimately help litigants in person, unrepresented people in court, be able to produce documents which are more accurate? From my experience, from my studies, when I've asked ChatGPT to generate a skeleton argument, and I find that it's not very good. Have you experienced that?
What was your prompt when you put it into ChatGPT?
I have to remember. Give a skeleton argument for an urgent interim injunction on behalf of a claimant. Just the outline.
Yeah, so free or paid version?
Free version.
Yeah. So will it help overall? So you find that if you just give it a blank slate, you'll get really terrible stuff back. So if I say, could you write me an article about AI? What it will push back is gubbins because it just doesn't have any direction. So it'll just bring everything in. However, when I have said, I want you to write me an article, this is the equivalent of this, I want you to write me an article about AI. I want the introduction to deal with this point, and I want you to bring in this event, and I would like you to comment like this and make sure that the end of the introduction has an interesting hook that leads into the following sections. Section 1, I want you to discuss the different types of AI and what they are currently being used for. Section 2, I want you to deal with this, so and so. So I'm actually giving it the structure, but I'm just not filling in the blanks. And that will produce a much stronger piece of work because you've done the thinking. And that's also important for your and any student's development going forward. You have to have done the thinking first. And then that means you are able to challenge, respond, and note where things are wrong or right. In those scenarios, it is really helpful. I don't use it for work, so I'd never put in private documents. I'd never name any cases. I never talk about anything specific when I use AI. So I haven't had that specific circumstance because I have never asked for a skeleton through that. It's not safe.
All the cases we get, the bar school are fictional.
Yeah, exactly. And that's why you can do it that way. I mean, obviously for bar school, I don't know what your requirements are. I assume that they say you can't use...
In examinations, they're not allowed to use AI. I only said this because it was my first drafting lesson and I had no idea how to even begin to structure it.
Yeah.
And it's really interesting when you have no knowledge at the beginning to see the answer it gives, and then once you know and you're able to do it, it's much more useful.
And from a litigant in person's perspective, you can see how they wouldn't know, because they wouldn't be on a learning journey to find out what was different from the first thing it got, from the last thing it got. And you do have that opportunity, which is really helpful. But that's the pitfalls. And then if you think about scenarios where it might be the first time you ask something and you'll never go on a journey to find out the end point. You're only having to do it because you're forced through a bar course at the moment, right?
Exactly.
And so how does that affect your progress as a practitioner if you don't ever develop those building blocks to see what the end product really should look like? And so you can see where there are risks for it to go wrong.
For a litigant in person, do you find that because the court can ask you to support a litigant in person if need be, do you find this is increasing with the use of AI?
Absolutely. And that's more of what that really reflects is how difficult access to justice has become overall. So AI is more a symptom of a different problem rather than a symptom of AI. You will not remember this, but 2012 and 2013 had really sweeping changes across the board on different aspects of access to justice. Some of them have been reversed, some haven't. But the change to legal aid in that period of time really stifled access to legal aid for family cases, some aspects of criminal cases. You also at the same time had a shift in the funding arrangements for personal injury claims, so civil claims, which is what brought in the qualified one-way cost shifting, and then the reduction of success fees from 100% to 25% that couldn't be recharged to the losing party. That means that you get a load of firms that are more risk averse, so they might not take on slightly riskier cases, and so all of those people have to self-represent, and then you have all the people who are dealing with family cases have to represent themselves. And at the same time, this has been reversed, but then you had employment tribunal fees came in around that same time. And so why is that relevant? Because the structures in place to deal with employment tribunal claims reduced massively because there were so few claims that were going through the ET. And even after the Supreme Court decision that resulted in the removal of employment tribunal fees, the architecture for the employment tribunal has never bounced back to what it was before, which means that you've got this very clunky, slow process in employment tribunals, which then in turn means that solicitors are more cautious about cases that they might take in front of on behalf of litigants or on behalf of claimants, because it will be a long time before they potentially get any payment if the payment is coming out of the person's damages. So you see all of these small features that happened over 10 years ago.
They all build up to a bigger problem.
Exactly.
Justice.
And you have people who have legitimate grievances but not the language to be able to come to the court and explain it. And even though we have, as an industry, tried to make the courts, the legal process, less legalistic, less legalese orientated, it's still impenetrable because it's an industry, and any industry has its lingo. So it's not meant to be a criticism of law. If I go to a corporate environment, they'll all have acronyms that I've never heard of before, because that's just a function of working in a space. But everyone connects to law or might connect to law in some way, and then they are stuck in a language that they don't know. So they are tempted to use AI because maybe AI will know, and not a lot of people have time to understand the nuts and bolts of how AI works. That to them is a good enough response, and in their mind they may think it is better than what they can produce. And I'm not necessarily sure that it is, but it is not a reflection of AI, it's a reflection of the system that it's now available.
It's a reflection of the situation many people find themselves in. There's another way that AI is being used, or at least is being piloted, which is that AI is being used to adjudicate, that is, decide low-value cases, so low-value disputes. For example, I have a defective kettle and I wanted to bring a claim against a shop that I bought it from, and it's been piloted that I could use an AI could resolve this dispute. Could be quite straightforward, legally speaking. Do you have any thoughts on that?
My own view is that it's not, But then I have to qualify it to some extent. Low value claims, so what we would see in the small claims courts, road traffic accidents, etc., all of those insurance-backed claims, they were already, before it got to court, being dealt with on an algorithmic basis. So most insurers will have statistical models about certain sets of facts, whether or not that is going to be more likely than not one side was responsible or the other side, and they would settle stuff before because it was insurer to insurer. I don't know the detail of what they have, but I know that they had those kind of things at the background. So it's just sort of translating that into a slightly more exposed part of the justice process. And arguably, if it's the same kind of low value, high volume, why would you not have a probabilistic answer? Because that's just as good as a 50-50 from a judge. But I think that overrides a couple of facets of how we conceive of justice, which is you have a grievance, you try and resolve it with the other party. And I think it's at that point where AI might be helpful. But after you can't resolve it with another party, you go to an independent court that's listening to you personally, listening to the other side personally, and then making a decision. And so it's having the faith that the institution that you believe in to administer justice is actually capable of doing so. And if you just hand that over to a computer, I'm not sure that is good for people's faith in the justice system when at the moment it's already having some difficulties in its popularity. So I think that is a much bigger concern. I also just do not think that it is capable of making the right decision about cases. And a lot of the work that I do for Advocator, so Jack is the tech and I deal with basically everything else, but I'm pushing when I'm dealing with our wrapper and our model to see which ways it goes and why it decides this person's advocacy is good, that person's is not good, how it decides to rank people, because we've run an AI mooting competition, and how it produces its answers about who is scoring that and who is scoring that. And because of the variability in it in certain circumstances, I wouldn't be confident in leaving that kind of bandwidth available for people's actual cases, even if they are low value.
It's really fantastic, really interesting to hear that. I just wanted to link that to earlier about what you were saying about access to justice and litigants in person. It's interesting how the issues to using AI to decide disputes are common to those faced by litigants in person, which is essentially how you can't quite trust the content properly.
I think that's right. We're obviously talking about this in the context of both of us being, I suspect, fluent English speakers. It's my only language, and you think about things through the lens of, well, it's going to work because AI is programmed in English for the most part. But there are a lot of studies that have been done recently which talk about how AI can struggle with being able to provide an output if English is not the primary language. And so you get a variability of responses, especially if it's not Western-centric languages. So it's quite good at translating Western-centric languages, and then you start to get into other sorts of languages, and the outputs may not be as helpful if the person is interacting with it in their own language. And they might never really know that, well, they couldn't possibly know that what they're getting will be different from somebody who might be speaking to AI in English. Yeah. So you've got that. That's not even an intentional bias. Then you've got the unintentional bias, which is a reflection of the world that we live in. The stuff that we write reflects a bias that lives in the world, and we train it in that way.
Yeah, and the fact that so many things which you need to research for a case aren't necessarily immediately accessible or obviously needed for that case. There's also that issue when you put it in, it may not reach what you actually need. So with that in mind, I just wanted to ask your opinions on my bar course studies and the students in general. like I said, using AI is quite common in the sense when you don't know anything from the onset, you might think, how can I find it? Or you might use it to spell check something. And I think that the general practice for how students are actually using it are quite distinct and separate from its use at the bar. And there is an interesting disparity there. Do you think there might be any trends at the bar towards changing its attitudes in using AI or not?
Yeah, so I think that there is always a diversity of how people decide to manage their practice. There is, I can see, really good opportunities to use AI in the administrative parts of it. So I will always ask my clerks a standard set of questions if they ask if I'm available for a case. It usually relates to how many pages is it, how long are the particulars of claim, how long is the hearing. They're really boring questions, but I need to know the answers to those to make a decision on whether or not I have capacity to be able to take it on. And if you had an agentic AI workflow, which is it gets an email, it can read the context of the email that it's asking me whether I have capacity for something, it can generate a response to my clerk without my involvement just to ask those questions. And that's absolutely a use case. Unfortunately, we don't use that at the moment because that requires everyone's buy-in in Chambers. But you can see that that's a really helpful use case.
And that's possible.
Technologically, that is possible.
Practically possible. Would that actually happen in a Chambers?
Well, that's the part of it. So it's a global buy-in on whether or not that happens in a Chambers, and people will get more or less comfortable with the idea of using it. Hallucinations are, I understand from benchmark testing, reducing in number. So as the models get better and are trained better and they have better wraparounds with them, harnesses, the instances of hallucinations are going down. They're not nil yet, but they are going down. And so the question about how you use it, it will come down to, again, how secure do you accept the system is? So if you ever have to deal with a private case, how are you confident that the information is going to stay confidential? Now, obviously, that's been solved for some law firms because they use Legora and Harvey, and that's putting client data into a model that then gets transferred to, I don't know who they use, the LLM that you use behind that system. There's obviously a way that you can have it safe. But I think for the bar, the problem is that the substance of the work that we do is never going to be capable of being dealt by
on an individual basis.
It's confidential and it's individual. So by the time that people come to us, so they will have gone to try and solve the problem themselves, presumably, we would hope. Then they'll go to their solicitor who would have thought through the problem. So by the time they come to counsel is because they haven't figured out the answer to the problem. So what you're getting is not a probabilistic set of facts. You're getting unusual. Because if it was answered directly by a case, they wouldn't need you. They are asking you to look at different cases and decide how these things come together. The adverse impact might be felt much more in junior practice because there are more common cases. But even then, any barrister will tell you that they got sent to deal with a very simple hearing that should have been super straightforward and that actually just turned into a complete disaster because there was one fact that came out of nowhere and suddenly they were dealing with a much more complex case that if everyone had known that fact beforehand, they probably wouldn't have sent you. And that's the aspect of being a barrister that is so variable that you can't standardize it. And so I don't think that AI will overtake the functional tasks that we do, the very essence of the work that we do. But if it takes away the boring bits, oh, yes, if someone could do my billing for me, yes, I don't ever want to have a look at my billing again. If it can just analyse from how long I'm in a document and then post that onto my worksheet, that would be ideal. But I don't think it's going to take over our job. I think that AI, so for myself, I use it for like I said, the things that are best satisfied for probabilistic stuff. So I will check or run posts that I want to put on social media. Often I'll go back to my original draft, but I like to stress test whether or not the way I phrase something is I like it. If I have to do small pieces of information, sometimes I get stuck on a word. So, when you're trying to think of a word that fits into a sentence and it's on the tip of your tongue, you can't quite get there.
I do that
it's
as well.
And I just will go, okay, and I'll use a very fast model. So I'll use Haiku, which is a low compute usage. I'm thinking of a word that says this, but this, it's a single word. I think it begins with M, and then it will give me all the options that I might be thinking of. Yep, that's the one, move on. So it moves past that, that writer's block that you get, like you just have a sentence, you can't quite reach it. Or sometimes as my roommate in Chambers, he was like, there's this case and this happened in it, and I can't remember what it's called. And I was like, one moment. And I just went to Westlaw AI case. These are the facts. This was the principal. What's the name? Popped it out. And that is exactly what is helpful for. Obviously, you check it. But with Westlaw AI, it's in the system, so you can just click it and make sure it's the right one. So those are really helpful use cases for it. And then, obviously, with Advocator, there is an aspect of it that's more business orientated. So it's not secure documents, fake cases, that sort of thing.
Quickly talk about Advocator? Could you explain what it is?
Yeah, sure. So it's an AI advocacy training platform. So at the moment, we're at the beginning stages of it, but what effectively it involves is you create your profile. We have a number of exercises that reflect pupillage advocacy exercises. You record yourself after you prepare the exercise, so delivering the submissions. Then it will provide you feedback generated by AI. So it analyzes your audio, your visual, so your physicality and the substance of what you say, and gives you feedback on how to improve and what you did well, what you can take forward. And so we've got a number of different exercises across crime, civil, family. And that is what it's there for. We're also going to be putting a sort of debate facet as well.
To me, it seems like an excellent way of using AI to aid training, because it has nothing to do with how accurate the content it produces, but rather trying to train on advocacy skills.
Absolutely. It's practice. Our wrapper is to make sure that the feedback it gives you is accurate, because you don't want to be worrying about something that you actually didn't do. So it's important to do that. But it is really helpful to give you the opportunity to get that feedback. It's limited how much feedback you get in classes and then in moots and all of those things, and you have to do it all in front of everybody else. Whereas at least with Advocator, you can sit at home, record in the privacy of your own home, and then keep trying it if you want to, over and over, and getting that feedback, improving, trying again. You can try again with the same exercise, a new exercise, and that helps you to develop. And going forward, we're obviously in the early parts of the development, but going forward, we're looking at how you can use it for more complex tasks as well. So you might want to use it for, if it is right that AI takes over a lot of small claims, so there are fewer opportunities to go to court for small claims, you need somewhere to practice so that you can deal with fast track and intermediate track and multi-track cases. If you haven't done the small claims, you need somewhere to make mistakes before you then go into the higher stakes, and that's what we'd love to have as a practice forum for it.
So you're saying it could be used for barristers as well?
Yes, eventually.
That's amazing.
Eventually. So at the moment, it's obviously in its early stages. The future may be that you could input your actual papers into it and then test out what issues are going to come up, what the judges might likely to ask you, where have you omitted your thought process for your preparation. As video generated AI gets better, we're hoping that we'll be able to develop fake witnesses so that you're cross-examining somebody. Because the technology is there, it's just the videos that can be generated at the moment are very short. You can't have a long-term interaction like you would with a witness in a box. So those are all much further into the future, but at the moment it is a chance to just practice your advocacy in an environment with problem questions that are very similar to the ones that you'll get in pupillage interviews, probably in your assessments as well, and that's how it works. But why it's different from everything else out there, so it's not going to be helpful to do the same thing with ChatGPT, Gemini or Claude, is that it analyzes how you look at the same time. And so as an example, because I read through to make sure that things are moderated and it's sensible, the piece of feedback that I was reading, we can see that your advocacy would have improved if you weren't reading, because I can see from your eyes tracking across the screen back and forth that you are actually reading your submissions rather than just speaking to the camera. So it's a very refined ability to see what you are doing. It can be a bit creepy when I think about it, but we did design it that way, so I can't really criticise it for doing its job properly.
So you mentioned that Advocator is in its early stages. Would you be able to expand on what that means?
So we're just in the testing phase. So at the moment, it's available for people to use. You just have to go to advocator.com, advocator.com.
Be careful with the R at the end.
Yeah. And give it a go. So that's where you can find it. The website is available.
And it's free for everyone to use.
At the moment it is. We will start charging in a couple of months' time. So try it now.
Got to try it if we can't anymore.
Yeah, absolutely.
Thank you so much, Saara, for coming here today and talking about everything you know about AI. It's been so interesting and valuable.
Thank you so much for having me and giving me the opportunity to effectively speak to the students about how AI can be used well.